In this post, we're going to talk about using academic work in your answers. During your studies this year, you'll have encountered academic viewpoints on the law. That might be from your lecturers themselves, it might be from case notes, from articles, from books, from textbook chapters, even perhaps Twitter. And it is sometimes a challenge to know how best to make use of academic literature in your answers. So in this post, I wanted to say just a few thoughts about how to do things well and how to avoid some of the ways in which people do them less well. Relevance is absolutely key. It's never the case that simply tokenistically name-checking an academic gets you bonus marks. That's not how academic judgment works, how marking criteria work. Rather, what you want to do is draw on relevant literature to support the argument that you want to make in response to the specific question set. Good question to ask is, what's the point of using this particular piece of literature? Always think, when you're relying on academic literature, why you're using it. Sometimes judges and students and academics cite, say, a textbook for a particular proposition of law, in which case you might cite the textbook, or could you refer to a case that's also authority for the same proposition. Sometimes it's to refer to a summary of the law, so you don't have to go into all of the same amount of detail in a time-limited answer. And sometimes it's the intellectual argument that is being made, which you might be citing because you agree with it, or you might be citing because you disagree. But being conscious of how and why you're using the literature will help you in developing your argument in response to the specific question set. And one last point. If you're attempting a problem question, you may wish to draw upon academic literature, either because the article might argue what the current state of the law is, or argue for reform. And in your answer, it's fine to do both of those things. You just need to make sure that you're clear that you know what the law is or is generally understood to be, and then what you think it ought to be, and not conflating the two. But it's absolutely appropriate to refer to relevant academic literature in a problem question answer.